All right, that is Health Minister Dr. Willem Kiza, who is currently in the Eastern Cape again. Well, a child who had cerebral palsy has died at the age of 5, leaving about 15 million rand estate. 3 people laid claim to that estate: the child's biological father, his biological mother, and his maternal grandmother. The child lived with his mother and grandmother. The father had not seen him since he was 6 months old. The mother suffered from depression, and the grandmother had stepped up to raise him. In its judgment, the High Court in Gauteng focused on the interpretation of parenting. For more on this, we are now joined by Warren Harris, a Director and Attorney at Harris Attorneys. A very good afternoon to you, Warren. Thank you very much for joining us here on SABC News.
Hi, Flo. Glad to be here, and hello to your viewers.
Now, no, this is quite, and I wonder if I'm correct to say that this is quite the groundbreaking judgment. How will it change laws that are pertaining to family law legislation, in particular in reference to the new, I suppose, definition given to the word parent or parenting?
Good question. So it is groundbreaking in that it brings an interpretation to the law, interpretation of the law in line with the South African reality. It opens up the door to persons who would have previously been excluded from inheriting from a deceased child. I would say that family law in South Africa has already progressed in some respects, as it has placed certain rights and obligations on grandparents already. I would say that this has more of an impact on the Interstate Succession Act, which is normally very, very strictly interpreted. But I wouldn't call it a new definition to the meaning of parent, as it doesn't actually change that meaning.
Yeah.
It rather extends the definition to include those that do what parents would normally do, but are not actually the parents.
Yeah.
So a caregiver.
With a judgment like this, other laws will ultimately then be affected. I mean, you mentioned the Interstate Succession Act, for example, but I'm also thinking about the Children's Act. What do you see as being the most beneficial part of this judgment, or perhaps even the negative, if there is one?
Okay, so this may open up the door to extended family members who have assumed the role of a parent, having a claim to the benefits, rights, or any other claim that a parent would normally have over that child. The Children's Act deals mainly with parental rights and responsibilities between the children and their biological parents. This judgment may extend the roles and responsibility to extended family members if they have assumed some, if not all, of the parental rights and responsibilities. So there is some positives to this, in that those that are taking care of children who are not their own biological children stand in for the parent completely, including succession. But there also creates a level of uncertainty in the Interstate Succession Act. It creates a standard or a degree of care over a child, which a person has to prove, and a court has to either assess objectively or subjectively in order to determine whether that person was actually the caregiver of that child. So there are pros and cons to this judgment.
Yeah, we have often seen children mixed up in disputes that are pertaining to, the passing of a parent when coming to issues of succession. But how often does it really happen that it is, the other way around, especially when we're talking about a minor child, which happened in this particular case, where the parents are involved in dispute about succession, about a child, when a child passes? Is this something that isn't quite often in the cases that we see in our courts?
Yes, so it's not the natural order for parents to inherit from their children. While it may seem a strange set of circumstances, this is the reality that we face in this country. Is that, and it's that a lot of the primary caregivers in this country are not the biological parents or they are extended family members. And in the event of such an occurrence happening, I would say that it would frustrate the caregiver, who often has to sacrifice a lot to care for their child, not to have a claim to that child's estate should they pass on. It may not be a very common occurrence now, but it does happen. I think this judgment has created some certainty around any such future claims. But I do believe that now that this judgment is out there, we are going to see a large spike or an increased litigation on matters such with similar facts, where a child has left a substantial estate and parents and caregivers are fighting out in the courts to try and inherit that estate.
Yeah. Warren, thank you so very much for giving us your time, sir. Warren Harris, attorney, family lawyer, as well as director at Harris Attorneys. We appreciate your time, sir.